My name is Edwin Vieira. If I have any claim to fame that would be relevant to this conference, it is the book that I wrote, actually originally in 1983, and then it was revised upwards in double the amount of typeface in 2000, called Pieces of Eight, referring, of course, to the Spanish mill dollar, which is the constitutional dollar, Article 1, Section 9, and the Seventh Amendment. We come to the Federal Reserve System in comparison to the Constitution, and we see contradiction and antagonism. Of course, the Federal Reserve System, as anyone can intuit, if you will, simply from the statute as amended and obviously from the way it operates, is a form of central economic planning. And if the 20th century taught anyone anything, it is that central economic planning doesn't work. So one would wonder how, under the Constitution of the United States, we have a system of central economic planning, which unfortunately integrates the worst aspects of bank and state, because the government, the general government in Washington, has made itself the surety for the banks, and through the banks for the various financial houses with which the banks are allied, and therefore the banks and the financial houses hold the public hostage, potentially indefinitely. Now, if we come to the constitutional propositions, I don't want to go into great detail of that. I wrote a 1,700-page book. When I studied quantum mechanics at Harvard, we had a professor who didn't pay much attention to questions coming from the audience where the answers were in the bibliography that he had passed out at the beginning of the class, which was about as thick as the New York telephone directory. And his response was to those questions, "Printing has been invented. Take advantage of that." But I will cover two aspects of it. Kind of the basic aspect, Federal Reserve System generating currency or money. And of course, with respect to the banks, that is a form of bill of credit, or discredit, if you will. And certainly with respect to the general government in Washington, because Title 12 of the United States Code, Section 411, makes Federal Reserve notes an obligation of the United States. So we're dealing with a statutory, clearly statutory bill of credit. And the question arises, how can the general government generate bills of credit on its own, or delegate in some way to a private cartel the authority to generate bills of credit that will be credited in some way by the general government? And the short answer is, if you go back to the U.S. Constitution, go back one step earlier, Articles of Confederation gave the Continental Congress the power to borrow money and emit bills on the credit of the United States. And those bills that it emitted were called the continental currency. And all of the state governments assumed that same type of authority. Now, when the Constitution was presented in its first draft, at least, in the Philadelphia Convention, that language from the Articles of Confederation was used. Congress shall have the power to borrow money and emit bills on the credit of the United States. And in a rather acrimonious debate, which you can find in Madison's notes as one example, those words, "and emit bills," were struck from the draft of the Constitution. So Article 1, Section 8, Clause 2 now says, Congress shall have the power to borrow money on the credit of the United States. It doesn't say anything about bills. And one would think that, given that the powers of Congress are solely the powers delegated to it explicitly in the Constitution, that that power to emit bills was proposed and then stricken in the convention, that the Constitution denies Congress the power to emit bills. Pretty simple, right? Wrong. Because you have this intermediate institution called the Supreme Court, which makes mistakes every day of the year. For those people who think the Supreme Court is some kind of Delphic oracle that gives us the right answer, read its decision in Payne versus Tennessee, Volume 500 of the United States Reports, the greatest work of fiction ever written by man. And there is a footnote there, runs about 3 pages long in 8-point type, which gives you all of the opinions of the Supreme Court, which they say reversed an earlier constitutional decision. And those are probably ones that explicitly did so and mentioned that earlier constitutional decision. They didn't reverse by implication or by saying they were no longer going to follow that or that was outdated or whatever. So the list is probably about twice as long. And that's our problem. Subsequent to the Supreme Court, Civil War, the Supreme Court decided a number of cases, Knox versus Lee, Juilliard versus Greenman, which upheld the authority of Congress to issue what amounted to bills of credit, but of course did not uphold the authority of the Federal Reserve System, which didn't exist at that time. What's interesting about the Federal Reserve System is it's a cartel structure. and was recognized as such. You read the debates on the Federal Reserve Act, 1912, 1913. You'll see this being brought out and it being questioned as to whether that kind of a structure could be legislated by Congress. Well, it was. Comes Roosevelt and the New Deal, and one of the first things that Roosevelt put in his attempt to raise prices by killing pigs and pouring milk into the gutter was the National Industrial Recovery Act, which, if you read the literature of the times, people recognized as being parallel to Mussolini's corporative state system in Italy. Mussolini was not an opera buffa character at that time. Even Winston Churchill considered him to be a great statesman. In any event, the National Industrial Recovery Act set up cartels throughout industry. So there was a steel cartel, and there was a coal cartel, and there was a poultry cartel. And the poultry cartel question came to the U.S. Supreme Court, famous case, Schechter versus United States, ALA Schechter Poultry Company versus United States. And the question was, could Congress delegate to these private entities, these cartels which are called industrial code authorities, the authority it had given them to set prices and wages and regulations with respect to production? And the Supreme Court ruled unanimously that this type of system was, and I quote, unknown to our law, unquote. Pretty broad statement. Unknown. We couldn't find it anywhere. Wasn't there. They threw out the National Industrial Recovery Act on that basis. Why is the Federal Reserve System still with us? Because the Federal Reserve System came under a different statute. If it had been part of the National Industrial Recovery Act, it would have been gone. And subsequently, the courts have refused systematically to deal with this question for a very obvious reason. They can't solve it. They can state that a provision of the Federal Reserve Act or the whole bloody act is unconstitutional for this reason or that reason or violates some statute. But they can't tell Congress how to correct the problem. And there's the difficulty. So I can imagine that no justice, perhaps myself included, would want to throw the monkey wrench into the system without the ability to control the outcome of that process. And I think we're fairly sure to recognize that Congress is not going to solve this difficulty in the immediate future. The administration, the presidency, has powers left over from the Roosevelt era, what they used to call emergency powers. Pretty broad if you read them. 12 U.S.C. Section 95A is a pretty broad one. Gives sweeping authority to Secretary of Treasury and the President to control every aspect of banking activity in this country in an emergency situation, which they're the ones who, they're the ones who declare when that happens. But you can't expect that the administration is going to do that because it's obviously in bed with the banks. So the solution that I'm proposing for years now, whistling down a wind tunnel to hear the echo, right? Nothing ever happens. That the states take over this role as the primary actors in the adoption of an alternative currency. And the reason for that is ultimately, whatever this alternative currency is, it will have to be imposed on public officials, hopefully at every level of the federal system. There really is no uniquely private solution to this as long as we have government in this country. So until we adopt Norrie Rothbard's anarcho-capitalist position, we have to look at some aspect of government involvement as part of the solution to the problem. Well, number one, obviously we need an economically sound and constitutional unit of money. It has to be fixed by definition in some scientific manner. It should not require, should not promote central economic planning. It should not be easily subject to political manipulation. That is, we don't want to have to manage it by means of some kind of monetary policy that the politicians are going to deal with. It should be tied directly to the free market so that ultimately its quality and its supply are subject to the people's control. It should be as technologically advanced as possible, yet proof to the greatest degree against technological failure or sabotage. There should be a simple yet effective means to introduce this unit of money into the present unstable monetary system as quickly and thoroughly as possible. And that should give the people of this country some degree of immediate protection from the crises that we're anticipating are going to continue, and that will enable the state and local governments and the free markets within those jurisdictions to continue to function in the event of some catastrophic failure of the present monetary system. We also want to rely on competition in the free market as much as possible to promote the use of this money. We want to protect the people of the state and local governments who adopt this money against intervention by rogue officials from the general government in Washington. And that's a very interesting question, this intervention question, because a lot of people say, well, this problem could be solved through private action. All private individuals have to do is to begin making their transactions payable in Bitcoin, some alternative currency, gold or silver coin, whatever. You can write so-called gold contracts. They were made unenforceable the Roosevelt era, but then they were reallowed by statute in 1977, 1978, really. So it's certainly legal to make a gold or silver or Bitcoin clause contract which states that this contract can be enforced only through the payment of whatever falls into that payment category. And according to decisions came out of the Supreme Court, interesting enough, after the Civil War, in the gold clause era, when people were making gold clauses to protect themselves against appreciation of paper money, those clauses have to be enforced specifically. That is, if they say payment in gold, they have to be paid in gold or in silver or Bitcoin, whatever. The courts have no leeway there. So why doesn't this happen? As you see, depreciating paper currency, why aren't more of these contracts being made, certainly in the business realm and in the realm of long-term business transactions? The answer is regulatory costs. You take the Internal Revenue Service position on a contract that is made in the United States gold or silver legal tender coins, American Eagles, American Liberty silver coins, legal tender coins. They have specific dollar denominations impressed on them by order of Congress, statutory authority. Constitutional authority, for that matter. Congress has the power to coin money and regulate the value thereof, right? And the IRS takes the position that those contracts have to be measured monetarily in the so-called fair market value of the gold or silver Federal Reserve notes, not on the face value of those coins. Notwithstanding that the Supreme Court in 1878 specifically addressed that question and said the opposite. The Thompson versus Butler case. So now the IRS says, well, it's a frivolous position if you take that position that the Supreme Court itself has said is correct. So what I have been proposing as we go through the states, Article 1, Section 10, Clause 1, no state shall make anything but gold and silver coin a tender in payment of debts, anything but, which means the states reserve the power to make gold and silver coin a tender in payment of debts. What kind of debts are we talking about? Generally speaking, those are contracts, probably commercial contracts in most cases, that arise where? In the state courts. So we have an explicit reservation of constitutional authority within the original body of the Constitution. This is not something that you find in the Ninth Amendment or the 10th Amendment. It's right there in the original body of the Constitution, and therefore it controls and limits all of the powers of Congress. The power to coin money and regulate the value thereof, the power to borrow money and implicitly to emit bills, which doesn't exist, but they say it does. All of those powers are limited by this reserved power of the states not to make anything but gold and silver coin tender of payment of debts. And the only thing I would expand on that is to say today we can use electronic gold and silver, which gives us all the technological advantages of something like Bitcoin, leaving the anonymity aside, ties us directly into the Constitution, ties us directly into the free market because it's using gold and silver which is generated by the market, and removes the states and localities and people within that jurisdiction from the overarching control of the U.S. government. And if the tax authorities want to deal with that, their simple solution is, for those transactions that are made in gold and silver, generate a new Schedule X. And people report those gold and silver transactions and pay their taxes in the medium of exchange that they've used. And I would be willing to bet that if this kind of a system were put into play, and actually the Supreme Court's already ruled it would be constitutional, Lane County versus Oregon, go read that case, that you would see a reversal of Gresham's law. That this kind of system would spread from state to state, locality to locality, and at a certain stage, even the people in Congress and the taxing authorities in Washington, D.C. would recognize that the only way they could keep up the real purchasing power of the taxes they were collecting was to begin to tax in gold and silver by accepting the new alternative system. Thank you.